Just FYI, so they weren't charged with any race crime.
Okay, good. Well,
They were charging. They were essentially charged under acting under state authority, and so this is the failure of civil rights. So just so everybody understands, if you're a sworn officer,
can we get the statute on screen? Can you share the relevant statute?
They don't have the statute, but it's essentially, I'm reading the article. I can read the article. I can share the article though.
I don't trust the article. The article.
Yeah, I wouldn't trust the article.
But it's saying exactly what they got. What they were convicted of,
okay.
But so in other words, if you're arrested,
oh no, you ruined it, Nate.
I ruined it for Kurt.
No,
yeah, but if you're acting under color of state law,
all three of them were
violating my civil rights. Go ahead.
All three of them were convicted. Was what I was.
I'm dubious. I'm dubious. I am.
Have you guys the Rodney King cops? That's how they got them, because even though they were innocent, they were not guilty. They still violated his civil rights because they were acting in the color of law.
But Rodney King kind of illustrates my point in some respects, because Rodney King, when you think about that incident and what was going on versus Chauvin and what's going on, and you think about what other officers could reasonably perceive in Rodney King, when they're getting him on the ground and just beating him with batons, and versus what Chauvin is, to my mind, those are pretty different factual pictures. So, I mean, I have no particular problem concluding that, the officers who are beating him and kicking him, Rodney King, on the ground and so forth and so on, that they all kind of have knowledge that this is a fairly brutal assault, that's pertinent knowledge to everyone. That seems reasonable. That knowledge imputation for Chauvin seems less reasonable. I am not convinced that a guilty verdict for all three of these officers under federal law is warranted.
Yeah.
And I take personal exception, or maybe it's professional exception, or both, I'm not sure, but either way, that we didn't get to see the trial. Because I will open the possibility that maybe when the testimony is offered, and maybe when the witnesses testify, maybe the analysis would change. But since I don't have that, I just get to be a bitter crank and say I'm annoyed and say it looks like the jury made a mistake.
Here is what the prosecution had to prove. The prosecutors had to prove that the officers acted under color of law, obviously being officers or government authority, and willfully deprived someone of their constitutional rights, including the right to be free from unreasonable search and seizures or unreasonable force. This is a pretty high standard. So what they're saying is that
intentionally.
Yeah, so that's what they're saying. They're saying that
purposefully,
because that they purposefully deprived Chauvin Floyd of his constitutional rights under state authority. Now Chauvin, I think he got. These other ones, I don't think so.
Chauvin, I have no particular problem with.
Yeah,
but for the other officers, willfully means the same thing as intentionally, which means the same thing as purposefully, which means it was their purpose and design. It was their goal and hope. It was their desired for outcome that he would be deprived of his civil rights. That's what intent is. Yeah. I desired that result. That was what I was hoping for. It was my dream that would occur. That is intent. For these other officers, with the warnings and with the one guy on crowd control and the other officers saying, maybe we should turn him over, I can't feel a pulse, and so forth and so on. You're getting to intentional in a jury. How are you getting there? How are you getting to that mens rea based on these facts? Okay. What does anyone want to offer the Steelman case the other way around? Because
sure, I'll offer for you.
Okay, Steelman me, baby, Steelman me.
For the two rookies, I can't do that. But for the officers who were there a longer time, I'm saying is that they're saying that it was that they should have known that you had unreasonable force after your 2 minutes, and then after those 2 minutes, that's 7 minutes. I think the sooner you stop, the better it is. But I think they're saying for those 9 minutes that you don't have to prove that they knew, but you have to prove that it's almost like they like any dummy would have known, right? And I think that's the way they're trying to do it.
I don't think should have known gets you there.
Not should have known, but that
you'd have to show willful blindness.
That's what I'm talking about. Willful blindness. They were willfully blind.
They purposefully. Again, going to intent, they purposefully put themselves in a position to deny themselves the knowledge. So if you purposely put yourself in that position, that's also intentional.
You can see it. You see it happening, and you don't do anything. You turn your head. You say, "Okay, I don't care." That's the willful blindness. I see it happening.
Or you think it's going to happen. Put your fingers in your ear. Go la la la. I don't see la la
That's
la.
willful blindness.
That's willful blindness, right? Yeah, that would do it.
Yeah.
So I think that the argument there for convicting them is the fact that they were saying that, you know, they knew that he didn't look good and they didn't do anything about it.
They checked his pulse.
They had their suspicions that he should have been turned on his side.
But that makes no sense though, because it's funny because checking his pulse is the thing that got them they got them convicted. We checked his pulse, so he did have a pulse. So now we're willfully blind.
Yeah, I mean, if they had not done that, that would have been willful blindness. Joe, what do you want to say? Looks like you might want to say something here.
Oh my god!
Yeah, you're miming.
Yeah,
Go ahead, Joe.
I was figuring that like speaking wasn't working, so I was trying to yell at you in sign language. To steelman it, not that I'm on the same page as you guys. This is a gross miscarriage of justice for them to be convicted. But to steelman the other side, I think that Kurt made a great analogy to slow boil, where it's like, you know, it doesn't start as a violation of civil rights, but eventually it gets there. Mm-hmm. So, you know, if Chauvin had been on him for 45 minutes, would you all say that that's not willful blindness?
Of course it's willful blindness.
Okay. By the other three. My point is, okay, so at 30 minutes, it's also still willful blindness. So the question then is, at what point does it become willful blindness? If I turn a fire under a pot of water and I walk out of the house for 20 minutes, I know that by the time I got back there, it's boiling. Mm-hmm. So if not overflowing or whatever. Yeah. So if you want to steelman it, not that I think that this is a fair way to judge them, but if you want to steelman it and try and find some sort of justification, you can say that they felt that 9 minutes was too long. Would 8 minutes have been okay? I don't know. But they're saying whatever it was, that 9 minutes is too long, that you should have known he would have been dead, which is such a stupid, ridiculous perspective.
Well, they should have known.
What? No, everyone would have known. Everyone would have known.
Yeah. Because they should have known. Kurt's going to get me. Kurt's going to be like, no, that should have known. Right. So you're right. Got to be careful.
Like recklessly disregarding. It's basically saying recklessly disregarding what obviously had to have happened. Is that it's obvious he would have died. That's essentially
recklessly disregarding.
Right.
Is not intentional, willful, or purposeful.
It's reckless. It's what you're talking about. Willful blindness is we see it happening and we're ignoring it like it doesn't happen. So it's a higher standard. It's saying that you actually see it happening and you're okay with it. So
okay. My point being that whatever it is that they feel that you agreed that they get to if they waited 45 minutes, this jury is finding that they should have known by 9 minutes. I think it's a bizarre perspective. I think it's insane to hold these cops to that standard. I'm not surprised. I'm not surprised by it, given the fact that it's George Floyd.
I could convict you on that. You know why? Because what I would do is literally, I don't play the video. I set a timer for 8 minutes and 32 seconds, and I sit there and wait. And then let the jury just wait for 8 minutes and 32 seconds. Okay. You know how long that sounds in your quiet room where you're just waiting for. Then
when there's nothing else going on in front of you, that's a long wait.
That gives you we can do it right now, and that half the people will leave, right? I'm saying that gives you that's very convincing. Like, damn, this is a long fucking time. So
yeah,
it gets you there. It gets if you got to get a prosecutor, it gets you there.
And my understanding is they did the same thing that they did in the Chauvin trial, which was bring in a lot of cops, a lot of experts. They had like 20 witnesses for their to put on their case in chief. So there was a lot that they introduced. So my guess is that they probably had experts testifying, saying, after 2 minutes, that was already like they would have known or something like that. He was unresponsive
Here's another factor that actually was really important. It's not steelman. This is actually a really important factor, and that is there was a crowd screaming, "He's not breathing. You need to get off him. Mm-hmm. You're killing him. You're killing him. You're killing him."
Yes.
And
he's not moving.
With them all screaming that, for the cops not to be alerted, like, hey, maybe they're not being hyperbolic. Maybe they're not being overly dramatic. Maybe they should have perhaps it could have alerted them to the fact that they were being sincere, that he was actually dying. And they were like, well, we don't care.
I mean, I wouldn't know for sure, but I'm going to take a guess. especially for the 9-year veteran who's doing the crowd control. Probably not his first time with a crowd yelling all kinds of shit that is probably bullshit from any objective perspective, right? I mean, crowds say all kinds of crap. I would imagine you're hurting him, you're killing him. And you look, if there was a videotape there, you'd be like, nothing like even remotely close to that is happening because crowds yell all kinds of bullshit.
Yeah.
So I'm not.
Those videos do exist too.
I'm not necessarily sure the crowd to the guy who's doing the crowd control. I'm not necessarily sure the crowd yelling all those things put him in a position of knowledge, because it's like the crowd says all kinds of bullshit.
But the prosecution may have just framed it that way. That was nice for the jury to digest.
If you're looking to convict, that's part of what you're going to hang your hat on. And we know this. And by the way, here, the interesting thing about this case is, as I recall, many people on the left were furious that the jury that was selected ended up having like 11 or 12 white people. It was like, it was almost all white jury. And they were furious that they felt there was inadequate representation of, by the, in an intersectionality scale. So
these high majority white juries are just thrashing these people like Arbery, right? Everyone else we heard about Arbery. There's 11 white jurors. It's not going to be any justice. Those people are doing life without parole.
Yeah.
So these white jury thing is not working out too well for these cops, or for these wannabe cops. They're going down.
But of course, all my skepticism of the jury verdict in the world. Nevertheless, of course, I, as everyone else on this panel, is well aware when it comes to appeals, right? Yeah. We all know that innocent till proven guilty is over now. That has happened now. Innocent till proven guilty is no longer a thing now. That's over. So now, from this point forward, when you're reviewing it, all presumptions are going to flip towards the state. They flip towards the verdict.
You're talking about in these nationally known cases.
I'm talking about in every case. I'm talking about as a matter of law when you appeal. I'm talking about as a matter of law.
He's talking about after you're convicted and you appeal.
Okay. So I was like, wait, what?
Yeah, no, on appeal.
Yes, the presumption flips.
Yeah, the presumptions flip, right? The Court of Appeals is going to interpret the verdict and interpret all evidence in favor of the verdict. All ambiguity is now going to be resolved in favor of the verdict. And so the question would only be, well, there's, on appeal, you can look for, some violation, obviously, of some sort of due process violation, some sort of improperty that way. But in terms of like an evidentiary picture, the Court of Appeals you'd have to show it's against the overwhelming manifest weight of the evidence that no rational jury could possibly convict on this evidence. And so I'm like, yeah, no, this is probably not going to work on appeal. Even I, as your uncivil, putting myself in the position of theoretical appellate judge, because I'm a good appellate judge, I would probably have no choice but to affirm this verdict, despite my misgivings, because the jury heard all those things and there's nothing for me to do. Yeah. So this is the part where I, as theoretical appellate judge, start to hate my life a little bit. But then, as Scalia said, a judge who always reaches the decision they want to reach is probably not a good judge.
True.
So.
But
a good judge, I'm going to grit my teeth as I say, yes, the jury had enough evidence to convict. This is totally a fucking true.
But I think, Kurt, you are talking about, because if the appellate court is looking at the factual finding, trying to overturn, saying that there are no facts, that standard is extremely high.
I know.
But we're talking about the laws. I'm assuming that we're talking about, is there any legal, like for Kim Potter? Kim Potter wouldn't be the jury. Right. It's more of a law. It's now you're based on the law. Was there abuse of discretion, which I think you do have in the Kim Potter case. I think Potter has.
Well, yeah, I mean, because you're there because you say no rational jury could convict, because as the judge pointed out several times, it's mistake.
Yeah,
and mistake kind of kills the recklessness element. Yeah. So it can't be both at the same time. So no rational jury can convict. You can get yourself there in Kim Potter, because of the judge saying the word mistake 8,000 times. I don't know how you get there in this hypothetical case. And maybe there are some other grounds to reverse, although I'm doubtful, because I'm sure the U.S. attorney, the U.S. attorney doesn't often make those kinds of mistakes. The U.S. attorney tends to be very good and tends to be very clean. Now, not to say always, I've on my own channel reviewed cases where the U.S. attorney screws up. Oh yeah. And sometimes the Court of Appeals forgives them anyway, incidentally. Normally, that's not the thing. So my presumption going in is, there's no due process problems. There's no problems with evidentiary issues. There's no problem with, things that were made at the time. Any sort of objection sustained or overturned either way would have to be abuse of discretion, because those evidentiary calls can be, it would have to be blatant on total weight of the evidence. You'd have to show that the overwhelming manifest way of the evidence, no rational juror could convict. So I, as hypothetical juror, given what I know, and just to show like how we have to put on different hats in law sometimes, right? I, as hypothetical juror in this case, am taking a look at this and I'm like, based on what I know, I don't see how I can convict. And then I turn on my Court of Appeals hat. And I say, I, as hypothetical Court of Appeals judge, don't see any way I can reverse the conviction.
Yeah.
So this is some of the things you have to do sometimes in law, and why it's important to make these distinctions important in your own mind.